We'll hear an argument in 19701 in re Farmers Texas County Mutual Insurance Company, a petition for writ of mandamus from Bexar County and the Fourth Court of Appeals District.
May it please the court, Mr. Chambers will present argument for relator. Relator has reserved 5 minutes for rebuttal.
Mr. Chambers.
May it please the court, justices. I have 4 things I'd like to address with the court, time permitting. First, I'd like to address why an excess judgment is the sine qua non of a Stowers claim. Secondly, which is perhaps the other side of the same coin, I'd like to address why consideration that's paid or promised by the insured to settle a potential excess liability cannot suffice as damages in a Stowers claim. Thirdly, I'd like to encourage the court to continue the bright line requirement of an excess judgment rather than venturing into the uncharted waters with no footing in Stowers common law. And last, time permitting, I'd like to address why the Fourth Court of Appeals was correct in holding that the trial court abused its discretion in refusing to dismiss Longoria's breach of contract case. Before going any further, I should point out that my first and third points contain language that I borrowed from Justice O'Neill in her dissent in Phillips versus Bramlett, a dissent in which Chief Justice Hecht joined. So why am I quoting from a dissenting opinion in a medical malpractice case, in a Stowers case arising out of a car wreck? And more importantly, why am I leading with a dissent? Well, here's why. You have to read the dissent in order to come to one very clear conclusion about Phillips versus Bramlett. And while the briefing has focused on the majority opinion, if you don't look at the dissent in Phillips versus Bramlett, you might walk away from that case thinking that it was only the majority that held the view that an excess judgment was an essential element or a critical element of a Stowers claim. But when you read the dissent, you realize all 9 justices in Phillips versus Bramlett 9 years ago agreed that an excess judgment was, in the majority's wording, an essential or critical court erred in entering a judgment in excess of the statutory damages count.
Mr. Chambers, it's your position that the insured precluded the excess judgment from ever happening by participating in a settlement, but your client participated in that settlement as well. In other words, you paid $250,000 toward obtaining a release. So didn't you, by participating in that settlement, preclude that? And what was the $250,000 for? Because that alone would not have achieved the release of the claim against the insured.
Yes, Justice Bland. The contract states that an insurer, that Farmers is not bound by a settlement that is entered into without its consent. But
right, but did Farmers consent to this settlement? Because your adjuster, Mr. Sheffield, says, enclosed, please find the $250,000 settlement check resolving our portion of the above matter. But of course, it's settled within policy limits, and you paid only 2/3 of that settlement.
Right, but Farmers should not be bound to a settlement that it did not agree to. So it agreed to fund $250,000 of the settlement that Ms. Longoria reached with Mr. Gibson. And that's the full extent of what Farmers agreed to. It never agreed to fund the other $100,000. So to the extent that Farmers consented, it only consented to the $250,000.
But why did it pay anything at all? In other words, it didn't think that the case should settle within the policy limit. And so why did it pay toward or participate in a settlement that was within the policy limit?
Well, of course, Your Honor, we have to go with what is alleged in the petition. And in the petition, it alleges that Farmers had offered $250,000 at mediation. A question that we haven't reached, because it's a Rule 91A motion, is whether or not settlement negotiations at mediation would even be admissible. But according to the petition, which must be taken as true, Farmers had already offered the $250,000 during settlement negotiations, including mediation. So that's why it agreed to pay the $250,000. But if the case is going to be premised on contractual liabilities, then certainly Ms. Longoria should be bound to the contract that she agreed to, and Farmers should be bound to the one that they agreed to, which was to pay $250,000 out of a $350,000 settlement.
So what would preclude insurers constantly saying, you know, we'll settle it within policy limits and say to the insured, if you kick in some amount of money, we'll kick in the rest. And we'll agree to that.
Well, nothing would prevent them from doing that because of the freedom of contract. But the insurance policy, which is also a contract, grants insurers, such as Farmers in this case, the right and the duty to settle or defend as the insurer deems appropriate. And so if the insured disagrees and wants to offer money to extinguish the insured's risk of a potential excess judgment, then the insured does so on writing checks from its own checkbook rather than from the insurance company's checkbook, because of the fact that the policy states that the insurer, not the insured, controls settlement negotiations. In fact, the right and duty to control settlement negotiations is their very premise of Stowers liability. So
right, and here the insurer agreed to the settlement, right, by participating in it. That's the part that I'm getting confused about.
Well, they agreed to $250,000. They did not agree to reimburse Ms. Longoria for money that she paid out of her own pocket to extinguish the risk that she had that there would be an excess judgment and that Farmers would nevertheless not be liable. I mean, that's the risk that Ms. Longoria had. She might have been held liable in excess of $500,000 and pursued a Stowers claim and lost. And in those circumstances, that's the only circumstance in which she would be personally liable is if she doesn't have a Stowers claim. So Farmers never agreed to that portion of the settlement. They should only be bound by that portion of the settlement that they did agree to.
Don't we want to encourage people in the position of this plaintiff to settle those types of cases, to mitigate the damages and just avoid trial, make things more efficient? And if you prevail in this, isn't this going to discourage them from doing that?
Justice Lehrman, there is a strong public policy towards settlement, but this court stated in Gandy just a few years ago, I guess that's been I'm showing my age, that was 24 years ago in Gandy, and this is a quote: "The bottom line is that public policy favoring fair trials outweighs our public policy favoring partial settlements." The settlement in this case was a partial settlement. It did not end the litigation. It should have, but it didn't. The attorney representing Ms. Gibson took up the torch for his opponent in the case, Ms. Longoria, and now represents her in a lawsuit against Farmers. And it has not ended the litigation. It has distorted the litigation. If the case had gone to trial, a jury would have assessed whether Ms. Longoria was negligent and what Mr. Gibson's damages were. That's what we call a fair trial.
It's also very, very expensive. And it's something that the legal system has been dealing with for many years, certainly the 20 years since the case that Gandy that you're talking about. And certainly for us to encourage that a trial continue to fruition in order to get an actual judgment, in order to handle these kind of cases, is not in the interest of certainly efficiency.
Well, now there's going to, if the court allows it, now there's going to be another trial. And instead of having a clear and straightforward question regarding liability and damages, as juries do all the time, instead, now we're going to have a jury assess whether or not Farmers' decision was reasonable in a context where we have no footing, no objective standard to determine what the case would have been worth had it gone to trial. And so now it's going to depend on expert testimony from lawyers hired by both sides to say, well, I've litigated for 20 years or 30 years, and in my opinion, but this is what would have happened if the case had gone to trial, and therefore Farmers was reasonable or Farmers was unreasonable. So now, instead of having a clear, straightforward car wreck case, we have a dispute among experts about whether it would have happened this way or what would have happened if that had happened. And the court should continue to require a bright line rule, which it has consistently required, and the cases are outlined in my brief, that there must be an excess judgment. It is the injury causing event, according to this court in Murray versus San Jacinto back in 1990. And
Chambers, wouldn't it be far simpler rather than having people, hypothecate about what the judgment might have been, just to recognize a cause of action for breach of contract?
well, the problem with that, Justice Busby, is that the contract, in order to breach the contract, one would have to come to the conclusion that Farmers did something other than what the contract requires. The contract requires Farmers to pay damages that the insured becomes legally responsible for. She never did. And the contract
also requires you to settle or defend. And I know you hang your hat on the as we consider appropriate language, but isn't that ambiguous? Because you could read it one way to say settle or defend, comma, as we consider appropriate, to mean that Farmers can make a decision about whether they want to settle or defend. But you could also read it a different way to say basically that you can't, if you choose as appropriate to settle or you choose as appropriate to defend, that also what you do within that choice is basically within Farmers' complete discretion, and you can never have a suit for a breach of that provision. But isn't the contract ambiguous on that? And if it is, how can you dispose of it on a Rule 91A motion?
Your Honor, the contract, there was a case cited in our brief that discusses this. There is no standard of care that's imposed on an insurer with respect to that contractual duty to defend. Now, there are tort duties.
So is it illusory?
Frozen now.
Now we can hear you.
Okay. What I was saying is the contract is not ambiguous. It gives the insurer control over the defense, and it is that control that gives us right to the extra contractual duty under the Stowers Doctrine. If you go back and read the original Stowers opinion, it goes on and on about how the insurer's contractual duty to defend gives rise to an implied duty that the court found.
But if you had that control, why accept a settlement within policy limits that you did not agree with? And that's the piece of it that doesn't seem consistent with your right to control the litigation and to determine whether to settle or defend. You decided to settle within policy limits, but you didn't pay that amount. And so why would your right to determine settlement preclude the insurer from saying you've got the benefit of the release? I'm sorry, the insurer, you've got the benefit of the release of liability here, but you didn't pay for it.
Well, Your Honor, the parties had an existing contract, the insurance policy, and it gave Farmers the exclusive right to control settlement negotiations. However, Farmers certainly can reach a novation, and I mean, this hadn't been briefed by anybody, but I'm trying to respond to your question. But the parties are free to come to another contract, which they did, wherein Farmers was agreeing to pay $250,000 to settle its exposure. That Ms. Longoria was willing to pay $100,000 to settle her exposure, which, as I explained, presupposes that she has no Stowers case. And that should have been the end of it. So the very fact that she paid $100,000 to extinguish her own potential exposure is premised on the notion that she doesn't have a valid Stowers case. And that's
Except didn't the plaintiff in this case make a Stowers demand? In other words, I'll settle within policy limits to the carrier. And in that case, then that doesn't seem to talk about potential exposure beyond policy limits.
Well, and that's one of my points. If Farmers really did breach its duty by rejecting that demand, then the risk of an excess judgment was already shifted to Farmers. That's what Garcia tells us. So if Farmers breached its duty by rejecting that demand, Farmers was at risk. The risk that Ms. Longoria faced was if Farmers had not breached Stowers. And she's free to contract and settle that risk, and she chose to pay $100,000. What Farmers was simultaneously willing to do was pay $250,000 to extinguish their risk of a judgment up to $500,000. So both parties here extinguished two distinct sets of risk, and there's nothing wrong with that. They're free to do that. What Ms. Longoria should not be free to do is make Farmers pay her share of that. And I see that my time has expired.
Any other questions?
I have one last question, Chief. On the, you mentioned that we shouldn't recognize contractual liability on the duty to settle because Stowers basically supplies an extra contractual basis there. But what about the duty to defend? If an insurer hypothetically comes in and fails to, has agreed to defend but fails to do anything, has not filed an answer or, anything like that, then and say there's not a Stowers demand. And so couldn't you sue for breach of contract for breach of the duty to defend?
If they in fact did not defend at all, then yes. And there's
right, or they did, or they filed a general denial and that's all they did. So they defended a little bit, but not very much.
Well, I would say that under the contract, they have a duty to defend to the end unless they settle in the meantime. So if they start a defense, then they haven't fulfilled their contractual obligations. And certainly there's remedies against the attorney for malpractice. If the attorney fails to defend, and the court has already held that the insurer is not vicariously liable for that. But from a contractual standpoint, the duty to defend doesn't end just because they filed an answer. Now, it may fall from contract into tort if we start talking about whether, well, should you have hired this expert or should you have taken this position or asserted that defense? You start transitioning from the contractual duty to the tort duty is what I would say under those circumstances.
Any other questions? Thank you, Mr. Chambers. We'll hear from the real party.
May it please the court, Mr. Kimmy will present argument for the real party in interest.
May it please the court, Justices, your questions and discussions with Mr. Chambers underscores that under current law, there is no legal bar to recovery that prohibits an insured from suing under both her Stowers and contract rights when she was forced to settle with her own funds because she was faced with excess exposure after her insurance company provided an inadequate defense and then refused to accept a reasonable settlement within policy limits. We disagree that this court has issued a bright line rule that going through and obtaining an excess verdict is necessary to bring a Stowers claim. We have shown and we have cited that this court's own opinions in Canal, in Keck, coupled with Couch on insurance and restatement of liability on insurance, that this court has often recognized those treatises, certainly the Couch treatise, that those opinions and those rulings provide the legal basis upon which this insured has brought both her Stowers claims and her contract claims. And in this 91A context, the Farmers has briefed and we have briefed and sent out hundreds of pages of briefing because there is no clear bar to recovery. And we admittedly, Your Honors, Justices, we admittedly explain and show that we believe this is the first time that you all have had to consider how an insured can protect herself when her insurance company, Farmers, and their in-house counsel failed to provide an adequate defense such that she was faced with excess exposure and excess liability, and Farmers was only willing to pony up a portion of the money necessary to get a settlement and not all of it.
Was Ms. Longoria truly faced with excess liability, given that in your role in representing the plaintiff in the underlying car accident, you stowrized the carrier? And at that point, don't all those obligations kick in and protect the insured from an excess judgment?
Your Honor, the answer to your question is yes, she was truly exposed, and here's why. In every Stowers situation, there is no automatic shifting of liability. And what has to happen, for instance, Farmers didn't come in and say, at that point in time when they would not pay the money, they didn't come in and say, hey, we've got you covered. If you get hit for more than that, we're going to cover you. They did not do that. And so what Ms. Longoria was faced with was this. She was faced with a damage claim that exceeded $1 million when she only had $500,000 of insurance. And she had to figure out whether she was going to let Farmers continue the gamble and she get hit for $1.5 million or $2 million, in which she would then have to sue Farmers and show that back at the time that they rejected the policy limit offer within limits, back at that time, that Farmers should have, and under reasonable care, should have accepted that. That's not a given. That's another lawsuit in every Stowers case. There is no automatic shifting of liability. And that was her problem. She, in good consciousness and under the duty to mitigate, determined she is better off paying the $100,000 to help buy her release, to get her out of the excess exposure that they created by forcing her to go to trial after late designating experts and getting them struck. That was her problem. And Your Honors, the first thing that they have said was, well, unless you have an excess verdict, you don't have a Stowers claim. That's not what was said in Canal. Canal said that this excess carrier stands only in the shoes of the insured. And we in Canal, we do not expand those rights. We do not make bigger or heavier burdens on the primary carrier. We simply say that when the primary carrier violates Stowers, we allow the insured and its subrogee to stand in their shoes and sue for damages proximately caused by that violation. And under that rule, Your Honors, if just change the facts slightly in Canal. In Canal, if the primary carrier was as recalcitrant as Farmers and only ponied up a portion of their primary to pay, and then the insured in Canal had to put in $100,000 to get to her excess policy, and then the excess policy insurer kicked in, you all say in Canal, those are all damages proximately caused by the failure of the primary carrier, for which in the shoes of the insured, you can sue to recover.
Justice Alvarez in the Court of Appeals opined in dissent that Canal does not apply when there is no excess coverage. What do you say to?
She did. And here's what we say to that. They are mistaken. Here's how Stowers applies. It applies when there is excess exposure. And that is, see, the duty in any Stowers case, the duty arises and is breached in the underlying case. And oftentimes you all, even in Phillips, you said, here are the Stowers facts. Stowers facts, they always exist back in the underlying case because that's the time when the duty was breached and the harm done. That is, there was an offer made within the policy limits. That's here. There is excess exposure that a reasonable insurer conducting their own business would resolve to avoid the excess exposure. So Your Honor, Justice Guzman, without excess exposure, there is not a Stowers duty. The peril at the time of whether you should take or reject the settlement, the peril is the potential of excess exposure. And without it, the duty does not arise. And you've said that in Phillips. When there is excess exposure, the duty does arise. And in Canal, they follow this. They say this is an equitable subrogation case. They say that excess insurer is using only the rights of the insured to collect settlement funds that he paid. And Justice Hecht, you, in your concurring opinion of that, you said, yes, and the damages are those proximately caused by the breach of the standard of care in the Stowers situation. That is, the excess carrier must show that he paid more than he otherwise would have, but for the negligent conduct. That's this case. And in fact, it is Canal in which the couch restatement relies on. It's not the couch, it is the restatement of law and liability insurance, section 27. And their comment cites Canal and says, there is substantial authority that an above limits verdict is not required before an action can be brought against an insurer that has breached the duty to make reasonable settlement decisions.
You represented Mr. Gibson
We did.
in the claim against Ms. Longoria.
We did.
Is there any covenant not to execute on that portion of the settlement agreement or remission of funds owed by the insured based on the outcome of this case against the insurance company?
Fair question, Justice Bland, and the answer is absolutely not. And what actually happened, there wasn't a payment with a wink and a nod or anything else. The Longorias paid $100,000 in hard cash to Mr. Gibson to get that settlement. After they made that payment, and only after they wrote the check and Mr. Gibson went off at the $100,000 in cash, they decided to pursue their claim against farmers. And there's nothing to the contrary. And section 27 is this case exactly. It says, if an insured breaches the duty to make a reasonable settlement decision by unreasonably failing to settle a covered action within the limits, when there is the potential of excess damages, the insured may make a reasonable, and to your point, Justice Bland, a reasonable non-collusive settlement with the claimant, notwithstanding any terms in the contract, notwithstanding the consent from the insurer, and then sue for that indemnity damages that they paid. Justices, that's this case. You all have said under head, you've said repeatedly, and insured is fully protected by its contract and Stowers rights. Okay, so and in the head case, what you all said, no, you don't need an extra claim. You don't need a duty of good faith claim. You don't need an insurance code violation claim. Why? Because you are fully protected by both your contract right and your Stowers right. Those are the only two claims we brought. A 91A challenge would be valid in this case if we were still before you claiming a breach of the duty of good faith or claiming an insurance code violation. We instead followed Canal, followed Keck, followed Davalos, which said when there is an inadequate defense, that's a breach. You can take over the defense when there's such a conflict of that nature. We followed that law. We followed restatement of liability. We followed Couch on insurance law. And we are here before you arguing whether there is a clear bar to recovery. And the only way that in this case there can be a clear bar to recovery is if you all today create one, which we believe you won't do in a 91A situation.
Mr. Kemme, you obviously take the position that you have a valid breach of contract claim, alleging that they failed to pay what they should have, which approximately caused the $100,000 in damages. If we agree with you on that point, does it matter whether we agree with you on your Stowers claim argument? In other words, wouldn't your client be just as satisfied if we held that there is no Stowers claim because there was no determination of excess liability, but there is a valid contract claim? And I'm kind of setting aside the legal arguments here. I'm just talking about objectives that you're trying to reach in this lawsuit and on this appeal. Would that satisfy you and your client?
So, Justice Boyd, that's a fair question. The answer to that is no, it would not, and here's why. We are in the early stages. We have done nothing other than plead the case. And true in each of these, in any case down at the courthouse, you should be entitled to plead every cause of action you have, and even in the alternative. And this is way too early for this court to shut down one claim, the Stowers claim, for example, by issuing in a 91A setting that they are now changing Canal, they are adding to Phillips, they are rejecting Couch in the restatement on liability, all that provide a reasonable legal basis for which to plead the case. It's too early, Justice, to let one go and have us choose one or the other. We have the right to fairly plead any cause of action we have that we can show and justify a reasonable argument under the current law.
But are your remedies different, Mr. Kemme, under Stowers versus breach of contract, or does it get you to the same place damages-wise if you prevail?
Fair question. The remedies are broader in a Stowers cause of action because you have tort type damages in a Stowers cause of action. They may overlap. For instance, the $100,000, in either case, that's going to overlap and you don't get 100 twice. But there are remedies within a Stowers claim that are unavailable in a breach of contract claim. And
going back to the sort of the underpinning of Stowers and the reason why an extra contractual duty is implied there, though, do you need to imply an extra contractual duty or recognize it in the context of a situation where you've alleged both, right, that they failed to defend reasonably by not designating the experts, and then in addition to that, they also failed to settle reasonably under the contract. I believe you're pursuing both of those, as I understand it. But if you have a contractual cause of action for that, then what does the rationale we used in Stowers support also providing a Stowers claim?
It does, Your Honor, and here's why. You all have, in many instances, have often held that in certain circumstances, there can be violations that trigger both a tort cause of action and a contract cause of action. And there is nothing inherent about claiming damages for the failure to settle a case and failure to use due care in the settlement of a case when you have the opportunity to settle within policy limits. There's nothing inherent about seeking those damages that are proximately caused by that negligent conduct. And in this case, we say it's clearly negligent, and that's the pleading, because they not only failed to take a reasonable settlement, but they did it, compounded it after they failed to provide an adequate and timely defense. And so there's nothing that precludes us from developing at the same time a tort remedy and cause of action, in addition to our legal right to seek indemnity under a contract for paying an indemnity payment that they well should have. And it may be at the end of this day, like you're asking, it may be the same damage, and then we have to choose to elect that remedy. That's just not today, not in a 91A setting. So we wanted to add, I only have 2 minutes, but I'm just going to end with this, Justices. If you look at the briefing, if you look at your questionings, if you listen to farmers' questionings, the notion that there exists on the books a clear bar to recovery, when the restatement and couch are using your Supreme Court president to advise us that we are well within our rights, when we only pled the 2 contracts that you told us to plead to make sure that we were fully protected, Stowers and contract. And in this 91A setting, the trial court, when they denied those 2 challenges, that trial court acted in complete discretion under the current existing law. This is not the situation in a 91A challenge in which you should take farmers' aggressive invitation to now supplement, add, or change the law to create a clear bar to recovery. And if we used 91A for that, instead of allowing the cases that are properly pled to go forward and be challenged in summary judgment, we would have a chilling effect on the development of common law. This is just simply a fact situation that has not been before the court, and we have been very careful as litigants who have pled the case to plead and use only the basis in law in which we have found by your authority and every other authority. And we'll end with that. We appreciate your questions, and thank you for your time.
Any other questions? Thank you, Mr. Kemme. Mr. Chambers, I believe you have 5 minutes for rebuttal.
All right, thank you. I'd like to address Canal first. In Canal, there was a judgment. There was an agreed judgment for $3.7 million, which was in excess of the primary carrier's limits and got into the excess carrier's limits. And Justice Hecht, in his concurrence, stated, quote, "I agree that if an excess insurance carrier is required to pay a portion of the judgment rendered against its insured, then there is a cause of action."
Mr. Chambers, what's your response to their reliance on the restatement and on couch?
First, the restatement addresses lots of states' laws. So does couch. The restatement has to recap laws from across the country. We've cited cases from states that have specifically held that an excess judgment is required. And frankly, when it comes to comparing Texas law to other states' law, you know, Texas created the Stowers Doctrine 90 plus years ago, and they grappled with a lot of these issues in the 80s and 90s, and somewhat resolved them, hopefully mostly resolved them in the Gandy case in 1996 when it struck down, sweetheart deals. But these arrangements where we can short circuit the process that the parties agreed to, because the parties agreed that the insurer would control the case, and the law imposes on them a duty if it all goes wrong. But if we short circuit the process and don't trust the process that the parties agreed to, then it tends to yield chaotic results.
You said again where the insurer controls the case. Is there any case out there like this one where the insurer participates in the settlement that precludes any determination about what would happen if the case went to trial, and that participation was part of an agreement that for a settlement within the policy limits?
Not that I'm aware of, Judge. I think this case has somewhat unique facts, but it's governed by law that is clear that we've cited. And in terms of couch, Justice Busby, there's also Appelman on insurance, and it's cited in our brief. Appelman specifically states that an excess judgment is required. So we have disputing secondary treatises that this court, just 11 years ago, all 9 justices agreed that excess liability was a critical element and the sine qua non of a Stowers claim. So if the court,
Mr. Chambers,
yes,
would your analysis be any different if the insurer in this case had refused to pay anything and the insured had paid all 350?
no, Your Honor. And that goes back to what I was discussing with Justice Bland. At the time this case settled, it was unknown whether Farmer's rejection of the Stowers demand was reasonable or unreasonable. So to that extent, it was unknown who was at risk, but certainly one or the other, but not both, were at risk of an excess judgment. Farmer's was at risk at least up to its limit. And if it really was unreasonable, it risked the excess judgment. But Ms. Longoria would risk the excess judgment if Farmer's rejection of the demand was reasonable. So multiple parties, and certainly the plaintiff bore the risk that they wouldn't get very much money if they did go to trial. All the parties who were at risk came together, agreed to a settlement. They should all get the benefit of their bargain. Ms. Longoria eliminated a risk that she created when she had the accident, which if we're right, was not contributed to by Farmers. Farmers obviously bore the risk up to the policy limit and above if they violated this. They should all get the benefit of their bargain, which was they eliminated their own risk in exchange for some certain. And it should not be incumbent on Farmers to reimburse Ms. Longoria for negotiating away the risk that she might lose both the automobile accident case and the Stowers case, which is the risk that she suffered. Lastly, in closing, I'd like to remind the court of something that Chief Justice Hecht said when he was on the Dallas Court of Appeals in Watley versus Dallas. To allow the plaintiff to release an insured from liability without also releasing the insurer is to give the insured the power to unilaterally extend the insurer's liability. This would defeat, not serve, public policy. Thank you for your time.
Any other questions? Thank you, Mr. Chambers.
Thank you.
The case is submitted, and that concludes the argument set for this morning. The clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable Supreme Court of Texas now stands adjourned.